Our second presentation will be given by Dr. Anita Vaivade on nature, intangible cultural heritage, and the law. Dr. Vaivade has been a professor at the Latvian Academy of Culture since 2012, and from 2013 and 2015, she has headed the Latvian delegation to the Intergovernmental Committee for ICH Convention. And beginning in 2017, she has been leading the Policy and Laws Chair Program on ICH at the Latvia Cultural Academy. I currently understand that she is working as a facilitator for the ICH convention. So now we'd like to hear from you, Ms. Anita.
Hello, thank you indeed for these introductory words. Dear ladies and gentlemen, dear colleagues, I would like to thank the organizers for this invitation to participate and contribute to the forum, as well as for their kind cooperation throughout the preparation of this forum. So now it really provides us a platform for discussing issues of our common concern, both globally and locally. Before tackling the question, why does law matter for our discussion and in what ways, I would like to start with some thoughts on nature and intangible cultural heritage. Nature and intangible cultural heritage are widely used as two distinct concepts, and as such, they are used in various discourses. Some may, however, see nature and intangible cultural heritage as being one. In other words, one may see both among humans and with other parts of nature. Nevertheless, I will pursue the distinct use of these concepts, as it is also the way legal discourse has been dominantly shaped internationally, as well as domestically at a global scale. Nature and intangible cultural heritage are profoundly and closely intertwined. Humans sustain their livelihoods through the use of natural resources and through a continuous advancement of knowledge in this respect. Natural raw materials are used for expressing human creativity in diverging forms, for instance, through crafts that have both functional and aesthetic values, including textile, as we can see in the picture. Human-shaped landscapes create soundscapes. They dwell in nature, learn from nature, and get inspiration from nature for their thinking and being in the world. And thus, they also build their identities upon nature. Humans also express their knowledge and beliefs about nature in diverse languages, developing conceptions and vocabularies that may further be transmitted through stories, poems, and songs. As one may read, for example, in a Latvian folk song, one among numerous such concise folklore texts revealing human being and living in nature, what could be wrong in living beside the edge of a vast, mighty wood? 5 stacks had I to plough my land, and 6 young deer to harrow it. Connections between humans and nature are expressed in so many diverse, creative, and colorful ways. Through such examples, we learn about both cultural and biological diversity worldwide. And these connections are also expressed in law in various ways and for various reasons. So let us first take a look at the way the connection between biological and cultural diversity has been expressed in international law. Over the last couple of decades, we have come to being aware globally and recognizing in international law not only the importance of protecting biological and cultural diversity, but also of their reciprocal connectivity. There are various international treaties that we might consider as source of international law, relevant to either nature protection or intangible cultural heritage safeguarding. But let me mention at this moment only 2 of them. The Convention on Biological Diversity, adopted in 1992, witnessed a global concern that biological diversity is being significantly reduced by certain human activities. In this convention, the cultural importance of biological diversity was also recognized, as well as the close and traditional dependence of many indigenous and local communities embodying traditional lifestyles on biological resources. Universal Declaration on Cultural Diversity followed in 2001. While adopted primarily with concerns for safeguarding world's cultural diversity, it recognized the contribution of traditional knowledge also with regard to environmental protection and the management of natural resources, and fostering synergies between modern science and local knowledge. Both of these documents recognize the importance of traditional lifestyles and traditional knowledge, with a particular concern about indigenous and local communities. However, this may be seen also beyond, speaking more broadly of diverse parts of society worldwide. International law gives us profoundly valuable reference for common understanding, as well as common standards and objectives, be it in the field of nature protection or cultural heritage safeguarding. At present, we see how global ecological changes reach us at local and domestic level and influence our daily lives. In a similar manner, the understandings agreed upon at international level need to find their expression in domestic law, in the context of diverging legal histories, traditions, systems, terminologies, and sources. Metaphorically speaking, national laws may have comparable patterns, as in the picture we see. However, they are necessarily weaved with different threads and on different looms. These legal differences and commonalities we may observe worldwide is also a tremendously interesting part of our cultural diversity. It is with this idea of the importance of domestic level and the potential richness of approaches we may find that with a team of French and Latvian researchers and in close collaboration with scholars in altogether 26 countries worldwide, we undertook 6 years ago a research project named Osmosis on the national laws related to intangible cultural heritage safeguarding. And I would like to acknowledge and thank all colleagues for this common journey of research, as well as all partners who have supported this undertaking. Our interest was, among other, to see how within the national legal patterns, these threads of intangible cultural heritage are intertwined with other fields of law. And environmental law was one of such fields of junction. The results of this study have just been published earlier this September in a collective monograph. In there, our colleague Professor Jérôme Fromageau explores the interactions between intangible cultural heritage and environmental law. As he analyzes, we may observe such interactions at national level, in particular regarding the management of natural resources, such as forest ecosystems and wetlands and water systems. In some cases, these management practices rely on the respect of local customary law. For example, in the case of traditional water tribunals, we may find such examples in different regions of the world, including, for instance, in Spain, irrigators tribunals of the Spanish Mediterranean coast, the Council of Wise Men of the plain of Murcia, and the Water Tribunal of the plain of Valencia. Or also in Peru, namely the traditional system of Corongos water judges. Both of these examples are recognized as intangible cultural heritage at the international level. Overall, we have observed in this research project that issues relating to the respect of traditional knowledge and practices are more and more taken under consideration when dealing with the management of natural resources. Because of their long history, traditional practices have largely proven their capacity to preserve certain forms of biodiversity. In other words, in most cases, sustainability is profoundly characteristic to traditional practices of local communities, reassuring their livelihoods through a sustainable use of local natural resources, and this needs to have its legal recognition. As Professor Fromageau has pointed out, I quote, "Even if it is true that certain traditional practices conflict with legislations pertaining to the protection of biodiversity, many of these laws address this tension by including some exceptions to accommodate these practices," end of quote. Thus, we may observe ways for finding balance between the environmental concerns and sensitivity towards traditional practices regarding the use of nature resources, including through setting exceptions in national laws. Let me illustrate this by some examples, which will be regionally closer to my own personal experiences. I have recently undertaken a research with interest in the way intangible cultural heritage is or could be used as a resource for sustainable development in Northern Europe. and how could rights-based approaches serve for that purpose? Therefore, I would like to propose some insights from this region. In the Baltic countries, Estonia, Latvia, and Lithuania, we see examples where certain traditional practices of local communities related to the use of natural resources, such as harvesting wild berries, are respected in the case of protected areas, such as national parks or regional parks. Further north, in the Nordic countries, Finland, Sweden, and Norway, so-called everyone's rights to enjoy nature, including forests, are protected, ensuring public access to nature, also on private lands. It means the rights to walk and cross the land, temporarily stay on it, and pick flowers, berries, or mushrooms. Meanwhile, in all of these examples, there is the obligation to remain considerate and respectful towards natural environment. Such examples allowing to legally maintain traditional practices do not mean that no difficulties would be faced in advocating for such a quest for balance. Often, advocacy is needed and is carried out regarding both domestic and international regulations. For example, Estonia, a country of numerous small islands in the Baltic Sea, with the long traditions of communities to use local natural resources, has advocated internationally for a sustainable scale for seal hunt and trade in seal products, acknowledging that the small-scale seal hunting and full utilization of the hunted seals is an old tradition of local communities. As we may read in its governmental report regarding regulations at the European Union level, I quote, "This question is important not only for resource-efficient behavior, but for the local communities of Estonia's small islands to keep alive their cultural heritage and traditions. Aforementioned communities are very interested in small-scale marketing, sell them as handicraft of the products made from hunted seals, in order to compensate the expenses spent on the hunt, and also to introduce the traditions of creation and use of these products. The lack of the legal ability to sell even a minor amount of seal products affects the tourism development of local communities and the preservation of traditions in certain areas." End of quote. Thus, we do see various layers of sustainability being involved, both environmental and cultural, as well as economic and social, which witnesses once again the importance of an integrated approach and a quest for balance. In conclusion, let me propose some prospective observations. A harmonious coexistence of intangible cultural heritage safeguarding and environmental protection seems to remain conditioned by the scale of use of natural resources. As far as such use concerns local communities and their livelihoods, traditional practices are, in most cases, profoundly sustainable and would merit their recognition in legal terms. The rights and interests of indigenous and local communities regarding their sustainable traditional practices of the management of natural resources need to be continuously addressed in further legal developments. And I believe there is a potential in putting the international intangible cultural heritage law in use for this purpose. I also believe the global attention to the implementation of the Sustainable Development Goals and their integration in various national policies and monitoring mechanisms will enhance the awareness raising at national level worldwide on the junction points between intangible heritage and environmental protection. However, there is still advocacy needed to raise awareness and to influence legislative processes at various levels, addressing the points of junction between environmental and cultural sustainability of nature-related knowledge and practices. In the end, these two fields of law, intangible cultural heritage safeguarding and environmental protection, have the same overarching goal to ensure the sustainability of living and being in the world, and to do so with respect towards both biological and cultural diversity. So with these final words, I would like to thank you for your attention, and I'm looking forward to the upcoming discussion. Thank you.